Welcome to the Tech-Savvy Lawyer.Page podcast. In this episode, TSL Labs Initiative presents a video overview of our November 17th, 2025 editorial, The Hidden AI Crisis in Legal Practice. We use Google NotebookLM to distill the key insights from the original piece into this accessible presentation. Whether you're a judge, attorney, legal professional, or simply curious about technology's impact on the law, this episode explores the often overlooked AI systems embedded in everyday legal software. Discover what you may not know about the AI tools already influencing your practice, and learn how this knowledge gap could put your license at risk.
The following is for informational purposes only. This presentation does not offer legal advice or create an attorney-client relationship.
We need to talk about a compliance crisis that's unfolding right now on the computers of pretty much every lawyer out there. And this isn't about the fancy AI you decide to go out and buy. No, this is about the AI that's already been adopted for you, hidden inside the software you use every single day. Let's dig into what's really going on. Yeah, I know, it's a dramatic question, but honestly, it's one that every single person in the legal field needs to be asking themselves. The tools you trust, the ones for drafting, for client communication, for research, they might be operating in ways that put you in direct violation of your ethical duties. And the scary part, it's all happening behind the scenes, without you even clicking a button. This isn't some far-off future problem, it's the reality of legal tech today. And look, we're not talking about some obscure fringe apps here. This is the bedrock of your practice. We're talking Microsoft 365, Adobe, Zoom, Grammarly, even your core tools like Westlaw, Lexis, CLIO, and Smokeball. Every single one of them now has AI assistants working in the background, and a lot of the time, they're turned on by default. So let's put a name on it. Hidden AI. Some of the source material calls it the invisible assistant problem. Basically, these features are analyzing, transcribing, and summarizing your work before you even think to ask them to. Now, the crisis isn't that these tools exist. It's that they're active and processing sensitive client data, often without any lawyer having a clue it's even happening. And this, right here, is the heart of the issue. This isn't just a tech problem to hand off to your IT person. This is a fundamental ethics problem that goes straight to your professional responsibility and, frankly, your license to practice law. So let's get into what the rules actually say. The American Bar Association has been crystal clear on this. Back in July 2024, they dropped Formal Opinion 512, and it puts the responsibility squarely on your shoulders. The old excuse of, oh, I didn't know my software updated itself with that feature. Yeah, that's not going to fly. You are on the hook, period. It all really starts with a foundational duty of competence under Model Rule 1.1. You've always had to stay current with technology, but this hidden AI stuff, it's a massive new stress test on that rule. It's no longer good enough to know how to use your software. You now have to know how your software is using your client's data. And if you think that sounds a little vague, think again. Comment 8 to the rule gets incredibly specific. It's not just about understanding Westlaw in general. You are now mandated to understand the AI features embedded within Westlaw, within Microsoft Word, within everything you use. There is absolutely no wiggle room here. All right, next up is the big one, maybe the most critical one of all, confidentiality under Rule 1.6. This is sacred ground for every lawyer. You have to make reasonable efforts to protect your client's information. But what on earth does reasonable efforts even mean when you've got invisible AI assistants reading everything? And this just puts it in perfect focus, right? You run a highly confidential client email through a tool like Grammarly. Well, you've just potentially sent privileged information to a third-party server. Or what about when Zoom's AI transcribes a super sensitive settlement talk? Where is that transcript going? Who sees it? You have to ask yourself, are you still making reasonable efforts? Then you've got Rule 5.3 on supervision. You already know you have to supervise your paralegals and junior associates. Well, guess what? That duty now extends to what the rule calls non-lawyer assistants. And they've explicitly said that includes AI. You literally have to supervise your software with the same care you'd supervise a human member of your team. And finally, it all comes back to your client with Rule 1.4, communication. You have an obligation to keep your clients in the loop, and that now includes telling them that you're using tools that will process their confidential data with AI, and, critically, getting their informed consent. It's all about transparency. Okay, so the rules are clear and they are serious, but to actually comply, you need to know where these AIs are hiding in the first place. So let's go on a little tour of your digital toolkit. Let's start with the tools you trust and pay for the most. According to some eye-opening research from Stanford, the generative AI in these platforms can hallucinate, that's a nice way of saying make stuff up, at a pretty shocking rate. A 17% hallucination rate for Westlaw is bad enough, but Lexis plus AI at 33%? That means 1 out of every 3 queries could be giving you fabricated case law. Just let that sink in. And it's not just research tools. Your communication platforms are a minefield. There's this wild story about the meeting assistant Otter.ai, where it just kept recording after the meeting was over. It ended up capturing a very candid and very damaging conversation. Now imagine that was your post-deposition strategy session. The risk of waiving attorney-client privilege is just enormous. All right, I know. That is a whole lot of risk, and it can feel pretty overwhelming. But the goal here is not to scare you into becoming a Luddite. It's to empower you. So here's a clear 5-step playbook to get this situation back under control. It's really a systematic process. First, you do a tech audit. Just figure out what software is actually in use at your firm. Second, you evaluate confidentiality. Read the terms of service. Do your vendors use your client data to train their AI? You have to know. Third, you implement safeguards. That means going into the settings and turning this stuff off. Fourth, you establish policies and train your people. And fifth, you talk to your clients and get their consent in writing in your engagement letters. So once you start down that path, it immediately brings up 2 more giant operational questions. How do you actually verify the work these AIs are doing? And how in the world do you ethically bill for it? On verification, we have the ultimate cautionary tale, the Mata v. Avianca case. Lawyers just blindly trusted the AI's output, filed a brief that was full of completely fake cases, and got hit with major sanctions. The lesson could not be more clear. You cannot delegate your professional judgment to a machine. You have to verify every single thing it gives you. Now, what about billing? Formal Opinion 512 is our guide here. If you're billing by the hour, it's simple. You can't charge for an hour of work if an AI helped you do it in 10 minutes. You bill for the 10 minutes. But if you're on a flat fee or a value-based system, you can benefit from that efficiency, but only if the client knows about it and agrees to it up front. And one more really crucial point on billing. The time you spend learning how to use all these new tools, that's on you. It's part of your professional obligation to stay competent. It's a cost of doing business, and it is absolutely not something you can pass along to your clients. Okay, so we've covered the rules, the risks, and the 5-step plan. But what can you do, like, right now, the second this is over? Let's get really tactical. Here's your immediate to-do list. Go into the settings for Microsoft Office and Adobe and see what AI features are turned on. Call your Westlaw or Lexis rep and ask them some hard questions about how they're using your query data. Audit the AI features in your practice management system. Review your policies on video conferencing and transcription. And please, put a recurring AI training session on the calendar for your entire firm. So here's the bottom line. These tools are incredibly powerful. They offer a genuine opportunity to practice law faster and more effectively, which is a huge benefit for your clients. But that opportunity comes with an obligation you just can't escape. You simply can't embrace the upside of AI while ignoring the ethical duties that come right along with it. In the end, it really is that simple. The AI is already in your office. It's on your computer, working silently in the background. Your only choice now is whether you are going to be the one in control, so you can unmask it, understand it, and manage it now, or you can wait for the consequences to find you later. The choice is yours.
We hope this exploration of hidden AI in legal practice has given you some valuable insights to protect both your practice and your professional standing. If you found this episode helpful, please like, share, and subscribe to support our work. For a more in-depth analysis on technology's impact on the legal profession, visit the Lawyer.Page blog and subscribe to our podcast. Until next time, stay informed and stay tech savvy.